We don't really have time for questions, so I just ask each of our guests maybe to do a 1-minute summary or response, and Janet will give you a right of response in case someone says something that you want to bring up. But if you wouldn't mind starting us off, Janet, with your thoughts on the issue of guidelines, as Cécile asked you.
Absolutely. As Cécile has pointed out, the Crown in British Columbia do have a policy in place. British Columbia is a very policy-intensive province. We are, I don't know if we're the most policy-intensive. Ontario, by contrast, is apparently has almost no policies. We have 2 policies which cover this area. Cécile has already summarized one of them. I just want to anecdotally say that most of the time when Crown says, oh, by the way, there's a policy that applies to this, most defense counsels start groaning and covering their eyes and saying, oh, no, please, not another Crown policy. Because normally that's where the Crown is being obliged to prosecute the case in a certain fashion. Policies, however, can be very powerful tools. I agree with Cécile in terms of providing guidance to prosecutors and when to lay charges and what public policy factors to take into account. The Crown always reviews its policies when major cases come out. So if the Supreme Court of Canada does decide these seminal issues in the cases that are going up, then the Crown will be reviewing its policy and determining whether or not its policy reflects the state of law once the Supreme Court of Canada decides on it. If the Supreme Court of Canada ducks the issues, which I don't think that they can, having read the factum of the Crown in the case from Manitoba, but if they do, then we're going to have to potentially look at trying to reflect at least the different appellate decisions. We haven't talked about some of the appellate decisions that not all of them in any event, but there might be some policy or appellate decisions that aren't in completely accordance with what has been described here. So we will look at all of those and potentially try to identify those issues.
Thanks, Janet. Jason?
Just 2 comments. The first is that I'm not entirely convinced that the current Crown Counsel policy in respect of HIV non-disclosure prosecutions has been updated since the JIT case, since the Manitoba Court of Appeal case. It might be worthwhile if there are any policy members of the policy branch of the criminal justice branch in the room. Might be an idea to have a look at it. My second comment would be that it's just not clear to me overall that the public health imperatives might ever fully, entirely, 100% line up with the criminal justice imperative to protect the sexual integrity of individuals. But to the extent that they can, it seems to make sense to me to have the public health experts in a room with the criminal justice experts and see how much overlap they can get, if only to facilitate the provision of advice for people living with HIV so that they can know, for example, if you wear a condom, you're not going to be prosecuted. If it's just oral sex, you're not going to be prosecuted. And simple propositions like that that make it easier to conduct your life, easier to live and communicate your HIV status and still maintain an active, healthy sex life. And might overall just reduce the stigma associated with HIV positive living.
Mark?
I'll just give one anecdote. I was thinking of what I could say. So the last 4 people that I've started HIV medications on in Ottawa over maybe the last 3 weeks have all had CD4s over 500. And these are people that have been holding on for a while, waiting to start treatment. And I now encourage people to get on treatment, and part of my motivation is the whole legal thing. So that has changed my practice quite a bit, thinking that there's no studies that show delayed treatment is better for your health. As the treatments improve, it clearly has to be an informed decision. Not everybody wants to get on treatment, but I think this is a motivation to get people on treatment and get them undetectable, and it should be very clear that if you're on treatment, you cannot be prosecuted, I think, and it's changed my practice quite a bit. We haven't even touched on drug users' transmission. We're dealing with a lot of people, women that we know are selling sex every night and sharing needles and all that, and so if you wanted to get into the next layer of this, then you'd be arresting whole swaths of people out there because it's very clear that they're not consistently disclosing. So you're just peeling back the layers and you're picking off the easy ones. But if you follow what you're trying to do out to the extreme, again, you're going to be building new jails to put HIV positive people in.
Okay. Now what I understand is Janet is not personally building those jails. Richard, if you want to sum up, and just before Richard speaks, if I can just take one moment to plug the HIV/AIDS Legal Network. There are membership applications at the back. You'll note that you paid a hefty admission price to come in, but we'd still encourage you to support the network. It costs very little to become a member, and the more members the organization has, obviously, the more powerful its political messages are around issues like HIV criminalization. Also, you get access to wonderful educational resources, so law students, lawyers, and others who are interested in this issue. I encourage you to look into that and to pick up some of those materials at the back. Richard, can you please take us to the bridge?
Sure.
Unless Janet has that right of reply there.
I think she does have a right of reply. Just to add to what you just said, there's also material at the back about a national lawyers referral database that we've been trying to build for some time, and we're weak on lawyers in BC. So if you're a lawyer and you're interested in occasionally providing services pro bono or for a reduced fee to people living with HIV, please pick up that information and let us know how we can be in touch with you. There's a form there you can fill out. Please, if you haven't seen them already, take the binders or the flyer about the binder of the resource kit for lawyers and other advocates that includes a lot of this information. All of it's also available on our website, and you can find that information back there, so please look for that. Two just sort of things of substance to let me say to wrap up. The first is that I think it is possible for this difficult issue to actually be discussed in rational ways, and if there is some good faith on the part of those who are very concerned about criminalization and want to see a much narrower application, and some good faith on the part of the Attorney General and prosecution services to accept that there ought to be limits placed on the law, then I think we can actually come up with some rational, fair, consistent application of the criminal law, and I think that's possible. It does require us to sometimes confront some difficult issues and maybe not take as categorical positions in some cases as we might otherwise. So I would just make a plea for having that communication, having that dialogue, and that dialogue has to involve community and criminal justice system actors if it's going to be effective. And I think, I hope that this evening is a contribution to that. The last thing I want to say in that spirit is I want to thank all of our panelists for participating, but in particular I want to thank Janet for coming and being here because indeed everything was a bit slanted. And we really appreciate that you were willing to come and not be the sacrificial lamb, but come and take a different position and challenge some of the things. That's, I think, part of the discussion. So thank you very much for that.
Janet, do you have any final?
When we prosecute, prosecutors must always take into account the views of all the parties, and in particular, I recognize that, of course, being prosecuted is traumatic for everyone, particularly when you are facing a disease that you probably obtained through no fault of your own. However, I am also obliged to consider the perspective of the people that were either exposed or actually infected. So I just wanted to close with that thought. Our criminal law focuses heavily on the accused, the rights of the accused, but I just wanted to point out that there is a whole other group involved in that system. Thank you.
So thanks very much for coming tonight, and please do pick up some of the materials at the back. And thank you again to the organizers and to the network. You did a wonderful job.